Hi everyone, welcome back to my channel Srilekha Potula. So, now in continuation with the part 1 of Arbitration Conciliation, let's go on to the part 2, which consists of the remaining two concepts of Arbitration Conciliation. Coming to the third part of the chapter Arbitration, Arbitral Tribunal. So, in this Arbitral Tribunal, we will be covering few sub-concepts, namely meaning what is arbitral tribunal. So arbitral tribunal means what? Arbitral tribunal is referred as arbitrator also. So he is a person who is appointed by those two parties to solve their dispute. So this arbitrator and arbitral tribunal are interchangeable words only. Here the unique feature of arbitration is already we know, like parties will get to select their own arbitrator. So who can be such arbitrator? Means any person who is capable of contracting, because this arbitration agreement itself a contract. So who can participate in the contract is the person who is capable of contracting. And the qualification, experience and norms will be specified as per schedule only. And coming to the appointment of arbitrator and its procedure, generally parties will jointly appoint the arbitrator. Each either this happens like both of them will appoint one arbitrator. Otherwise, both of them will appoint two arbitrators and those two will appoint the rest. Otherwise, it was appointed by unrelated person or any other institution. Number of arbitrators. How many number of arbitrators can be there? If nothing is prescribed, it will be considered as sole arbitrator. If not, arbitrator can be n number of arbitrators, but it shall not be even, because there are two parties who are in the dispute. If it is even and if it is equally distributed, then the argument will be continued, but it cannot be resolved. So even number of arbitrators are not preferred. So one or any other number other than even number. Next, requirements of arbitral tribunal. What are the requirements for a person to be an arbitrator? Like he can be of any nationality. This comes into this will be related. This will be considered when it is an international arbitration where two persons from different nationalities are having dispute and they have arbitrated the dispute, and he shall be capable of contracting, and he shall render the services for which he will receive the remuneration, and he shall be unbiased. He should not be biased, means supporting one person and acting in favor of him. He should not be like that. He should be unbiased. So these are the requirements. If needed, like then we can challenge the arbitrator. If there is like at the starting of appointment only, it should be clear. If the arbitrator is aware, like with any of the parties is having some relationship or some business relationship or some connection, he has to inform it earlier. If not, if it is turned out to it was known later, then he will be challenged due to such existence of direct or indirect past or present relationship or interest in any of the parties. And also it may give rise to doubt his independence and impartiality also. And other thing when we can challenge is if he is not able to resolve the dispute within 12 months of time, and he is not able to devote sufficient time to such arbitration, then in these two cases we can generally challenge him. And what are the instances which would give rise to doubt him? Means like he might be the previous he might have previous involvement in the case, or he's an employee or consultant or advisor, or had any business relationship with any of one party, or his close family member has some financial interest in one of the parties, or he is a legal representative of one of the party, or he has significant financial interest in one of the parties. So in these instances we can doubt him, like we can doubt his presence, like there is presence of bias. In these instances we can doubt the biasness also. Next, coming to the duties and liabilities of arbitral tribunal. What are the duties of such arbitrator? Means he has to conduct the proceedings without delay, and also he should not do it. He should do it expeditiously possible, but at the same time he has to avoid unnecessary delay. Next, to remain impartial at all times. He shall be unbiased throughout the arbitration process, and any biased outcome is no outcome, is considered as no outcome only. Any biased outcome is considered as no outcome here and would not be accepted under the law. And also, third thing is he has to keep all the matters confidential. Any matters disclosed by either of the parties shall be kept confidential within the arbitrator only, and he has to be deliberation, means he has to discuss the matter with each other thoroughly, and through a majority he has to render the award, and the award rendered by him should be a reasoned award. Next thing is he has to avoid unilateral communication, means just communicating to only one party. It is not the right way. So he has to avoid such unilateral communication. Also, he has to make sure the documents or communications from one party are communicated to the other party also. Next, he has to ensure that award or decisions the award and decisions he has made are complying with legal requirement, because any award or decisions made by him, if they are giving illegal effect, then the award shall be rendered invalid. That's why he has to make sure that award or decisions made by him are legal, are complying with legal requirements. Also, not only the award, but also he has to comply with the requirements of with the legal requirements associated with such arbitrator. So these are the duties and liabilities of arbitrator. We'll have a quick review again. Conduct the proceedings without delay, remain impartial at all times, keep all relevant matters confidential, deliberation, avoid unilateral communication, ensure that all documents or communication is communicated to both of the parties, ensure that award or other decisions made are met the legal requirements, ensure that he comply with the legal requirements at all times. So here deliberation might be somewhat difficult. Here we can consider it as he has to discuss the matter with each other thoroughly and render an award based on the majority. So deliberation equal to majority. Okay, these are the duties and liabilities of the arbitrator. Coming to the termination, removal, and substitution. What will be the need for such termination or removal or substitution of arbitral tribunal? Earlier we have covered the termination of arbitration agreement. What are the cases? What are the cases for such arbitration agreement? So if we recall the cases for arbitration agreement, it might be due to mutual consent, it might be due to death of the party, it might be due to operation of law, or it might be due to termination of principal agreement. So these are the 4 reasons for such termination of arbitration agreement. Next, coming to the termination of arbitral tribunal, what might be the reasons? First reason might be the arbitrator left voluntarily. He need not to disclose parties any reasons. He can leave the contract if he needs. So he leaves it voluntarily. First case of termination. Second case is mutual removal by the parties. The parties have mutually decided like we shall remove the arbitrator. Third thing is operation of law. What are the cases for such operation of law? Are arbitrator unable to continue. Like this could be any reason, like he has some personal reasons, or he's not able to allocate some time to this arbitration, or he falls ill, or any other family issues. Next, in arbitration process itself ends. How it ends means either final award is made or the award is not made within 12 months. So anyways, arbitration process is ended, or parties decide to discontinue with arbitration. In this case, either party. In 3 cases, arbitration may end. First is final award is made. Second is award is not made within 12 months. Third is parties decided to end the discontinue with arbitration. In the second point, parties involved decided to remove the arbitral tribunal. Here they decided to end the arbitration. So when arbitration is ended, arbitral tribunal is also terminated. So these 2 are different. Next, arbitration process. This is the operation of law. Next, when court decides that such arbitrator shall be removed, and for fifth is in other than above. So it's like one of the here the arbitrator is good. He is working without delay, and parties are satisfied with their performance. But one of the parties feels like he should be removed because he has doubt, like he is being biased, and he's not letting me know everything, like that. One party may complain and he may move to the court to remove the arbitrator. This might be the fifth case of such termination, removal, or substitution of such arbitrator. Now, what happens when we challenge when terminated? What is the next step? Next step is challenging. If like sometimes the arbitral tribunal might be challenged. First we have to challenge him, then we have to go to district court for domestic arbitration, or go to high court for international arbitration. After termination, what happens is either new arbitrator will be appointed by the parties as per original method. If not, they have to approach high court or supreme court um, for such appointment. Fourth concept of this chapter, going to arbitral award. So in general terms, arbitral award is nothing but like a decision by the arbitrator as per the dispute submitted by the parties. In the law language, we can consider it as conclusive determination as to the questions or issues or disputes that are put forward. Like it is the conclusion for such disputes which they have put forward. So what are the concepts covered over here in this arbitral award means general principles, types of awards, requirements of such arbitral award, and what are the like how to challenge an award, and what are the consequences of such challenge. Coming to the general principles, like here there are some few some details regarding arbitral award, like only the person involved in the arbitration can challenge the award. We can challenge the award within 3 months, extended by maximum 30 days, and we can challenge it before district court or high court. And if any party wants to stay on enforcement, it shall apply to the court also. Next, it says like the next concept is types of awards. What are the types of awards? Like there are final award, interim award, settlement award, additional award. What is the final award? Final award is whenever all the disputes are settled, and final award is given by the arbitrator. What is the interim award? In this final, it's like final award means one more thing we can add up, like it is award made in accordance with the law requirements. Next, second, coming to interim award, this can be two types of awards. One is which remains in force till final award is rendered. Second is it is final regarding the matter it deals with. So interim awards might be two types, like it is rendered valid, it is rendered as final till the final award comes into place, is rendered by the arbitrator. Second is it is final regards to the matter it deals with. So third one is settlement award. Settlement award is when the parties choose to settle the matter instead of resolving the dispute, then it can be considered as settlement award, and the arbitrator can help them arriving at a settlement. Like where two parties instead of blaming each other, let's come into an agreement. Like such agreement is nothing but settlement, and our arbitrator can help them to get the settlement, and it is known as settlement award. Final one is additional award. When it will be given means when the final award rendered, when the final award is rendered, but it found that certain matters are yet to be resolved. So there are some left out issues. Then we can request for additional award. Within 30 days of final award, we can request for additional award. Then he will submit the additional award also. What are the requirements of arbitral award? So we are talking about the award. What are the types of awards? Then what are the requirements of arbitral award? The requirements will be like it should be written, signed and dated. It should be reasonable and valid. Means it should not be invalid. Next, it must be clear. Means the award must be clear. The decision given by him must be clear. It shall not be vague. Means it shall not leave the parties in confusion, like what has been decided by the arbitrator. Next thing is on each issue it should be clear. Okay. Next, also it should not leave them with confusion. Also it should not leave them with an option to perform or not. So it should be very clear, like they have to perform it at any cost. Next thing is it should be capable of being performed. It should not be unrealistic task. Like it should not be unreal. Next, it should be legal. It should not be an illegal activity which should be performed by them. It should be legal only. Next, it must be delivered and enforced as soon as it is signed. As soon as it is signed, it should be delivered. Next, coming to the last part, another part, challenging an award. There are three how to challenge the award. Challenge of bias against the tribunal. Like Sometimes we may feel like the award challenged, like the award rendered is biased, so we can challenge that to the tribunal. Next, overstepping of jurisdiction by tribunal means tribunal may overrule the jurisdiction, then it can be challenged. If the arbitral tribunal is going out of its jurisdiction, then it can be challenged. Next, like a party is under some incapacity, specific grounds for reviewing an award, like a party is under some incapacity, invalid arbitration agreement, or party is not involved, is not given proper notice about such appointment of arbitrator or even for the award, and otherwise award deals with disputes which are not submitted for arbitration, like he is giving the award for disputes which are not submitted also. Next, legal requirements are not followed. So all these cases can be considered for challenging an award. What are those? This one is like different. It is like a party summoned incapacity, like the party is a minor, so it cannot be considered for, he cannot be considered for contract, and they have initiated a contract and they have given the arbitral award also. Then it can be challenged. Next, invalid arbitration agreement itself is invalid. So next, third case is some party is not given proper notice about such appointment or anything, like only one party is being involved and one party is appointing and the award was given. So party is not given proper notice. Next, award deals with disputes not disputed for not submitted for arbitration. So the arbitrator has given award for disputes which are not submitted to him. Next, legal requirements were not followed. So all these can be the reasons for such challenging. Also, the category 2 is like court can involve, where means the matter of dispute is not arbitrable, means it is not capable of settlement by arbitration, then it can involve and it can challenge the award. Also, the award is in contravention of India's public policy. Even in that case, a court can involve and it can challenge the award. Then what is the consequences of such challenges? It like 4. What are those 4 consequences might be there? Like first is set aside. It has no legal validity and it is no longer an award now. So completely that was set aside. Second thing is confirm. Like no wrong in this award. We can consider it as arbitral award. It's valid only. Modify. It shall modify. Like do these modifications and render the final award again. Next, remit back to tribunal. He will remit back the tribunal and ask him to rectify the defects. This completes the fourth concept of the chapter, arbitration, which is arbitral award. Coming to the last part of arbitration conciliation, which is nothing but conciliation. What is conciliation? Generally, it is also a method of alternate dispute resolution. But here there is slight difference between arbitration and conciliation. The thing is here in conciliation there won't be a judgment. Rather than it will be like settlement agreement where the parties are willing to come to an agreement and which will be supported by the conciliator. So this will be done through a confidential discussion. Coming to the concepts covered in this conciliation, we will be going to discuss the characteristics of conciliation. Next, the settlement agreement. Next, the most important part which is confidentiality. Coming to the characteristics, what are the characteristics of conciliation? There are like 5 characters which are namely voluntary, non-adversarial, assisted procedure, finality of settlement and confidentiality. So what does that mean, voluntary? Voluntary is like this the process of conciliation shall be voluntary. That means the parties have to voluntarily accept the agreement. It's not like they are forced. If it is forced, then it shall not be the binding. The outcome shall not be binding. So the first and foremost characteristic of conciliation is voluntary. Second characteristic is non-adversarial. What does this mean? Means here in this process, how it happens is the parties don't compete each other to prove themselves as right and the other as wrong. Rather, they are willing to get into a compromise settlement. So this is nothing but non-adversarial. So only these types of disputes shall be going to conciliation thing. Next characteristic is assisted procedure. Here, generally, as I have mentioned earlier, it is different from arbitration, and here conciliators are like supporters. The same is said in this characteristic, like conciliators are present so that proceedings are crafted in a manner to assist the parties to come into a solution. Means parties are already with a state of mind to get the settlement. So this conciliator will support them to come to a solution, to arrive at a solution. Next, coming to the fourth characteristic, finality of settlement. Outcome of proceedings here are final and binding on the parties. Now, that means the agreement which was settled and which was assisted by settled by assistance of conciliator, it will be binding on both of the parties. Coming to the last characteristics of conciliation, it is confidentiality. Confidentiality, we already know the meaning of it, like conciliator here and also the parties shall keep all the matters relating to the procedure and agreement as confidential, and it is also a basic characteristics of any ADR, any alternate dispute resolution. So as for this conciliation. Now coming to the conciliation, how this will work means like arbitration only, the disputes which are not prohibited by law can be submitted for conciliation, and here the number of conciliators shall be ranging from 1 to 3. In the arbitration, it is like sole arbitrator or any number of arbitrators other than an even number. But here, as it is not a case of like a judgment, it is rather like a settlement. So it can be even also, but the range can be 1 to 3 only. Either 1 or 2 or 3. Only maximum 3 conciliators can be present for proceeding with the conciliation. Next, how they will be appointed as general, same to arbitration only. Parties will be appointing them. Otherwise, they can get assistance from an institution or some other person for reference, for recommending the conciliator. Coming to the another concept of this conciliation, it is settlement agreement. What does the settlement agreement means? In settlement agreement, we are having like 3 points. First point is initial steps. What does this initial steps consist of means? The attempt of conciliation is to resolve the dispute and arrive at a solution actually. So, if the conciliator finds that the settlement is possible, then he have to reach out to the parties and explain about the settlement and get it resolved. And he has to settle the dispute, and he has to bring them to the agreement. So that is the initial step. Initial step is he has to work on the dispute, and he has to see whether settlement is possible or not. If it is possible, then he has to reach out to the parties and make them agree on the part voluntarily. Second thing is agreement. Here parties already found that there can be a settlement and they have reached out to the settlement. Then what a conciliator will do is he has to mandatorily authenticate the settlement agreement. When parties come to settlement by themselves, then it is called a settlement agreement or memorandum of conciliation that shall be authenticated by conciliator to make it valid. To make it valid, he has to authenticate it. Next is enforcement. Enforcement is nothing like the award or the final decision shall be binding on both of the parties. That is about the settlement agreement. Next, last part of conciliation is confidentiality. Here, the same thing is again repeated, like conciliator and both the parties shall not disclose the matters related to proceeding or agreement to anyone outside the process. And also here one more thing is like conciliator cannot act as an arbitrator or a representative for any of the parties. And also one more thing is the views expressed and the evidences collected over here cannot be used as evidence in arbitration or judicial proceedings also. And the another point which was not which was the basic idea is here the conciliator who was appointed by both the parties, after conciliator is appointed, both the parties shall submit the documents to him for proceeding with conciliation. Also here the award cannot be after conciliation has commenced, the parties cannot reach out to arbitration or court, cannot ouster of jurisdiction as in the case of arbitration. However, there is an exemption they can reach out to court if when it comes to preserving their rights. Like in arbitral award also can be challenged if there are some, if the arbitral agreement itself is invalid, or he uses unfair means for approaching that award. Like that, in this conciliation also, the conciliation award can the parties can also go to the court if it comes to preserving its rights. So this completes the complete chapter of arbitration conciliation. Thank you. See you all in next video.